Welcome to the Probate Nation. My name is Richard Ruddy. Estate planning often involves consulting with an attorney to discuss your goals and objectives, and typically that consultation seeks to gather information through an estate planning workbook you complete. A prior show in this series on revocable trust-based planning examined the personal information needed about you and your family, beneficiaries, and advisors. We refer to these people as the who in an estate plan. Our show tonight and next week will focus on the what in an estate plan. This is an inventory of the assets you have. The goals of these shows are to educate you as to the importance of this information, provide tips to consider in handling each asset you have, and identify quick fix pitfalls you should definitely avoid. We are pleased to have with us tonight two Northern Virginia estate planning attorneys. They will lead us through a typical estate planning workbook that gathers asset information for a revocable trust-based plan. Let me tell you a little bit about our guest. Todd Spignardo is an attorney with Rees Broome based in Tysons Corner, Virginia. His practice focuses on estate planning and administration in Virginia, Maryland, and the District of Columbia. He is a graduate of the College of Charleston and the George Mason University School of Law, and is also a member of the Northern Virginia Estate Planning Council. Our other guest, Dominique Braggs, is the founder of the Braggs Law Offices. She represents clients in Virginia, Maryland, and the District of Columbia on wills, trusts, and probate. She has a special focus on digital asset planning, one of the most overlooked yet increasingly vital pieces of a modern estate. She graduated from the University of Louisville Law School and is a member of the Northern Virginia Estate Planning Council. Please join me in welcoming attorneys Dominique Braggs and Todd Spignardo. Guys, thanks so much for jumping in and sharing your expertise. We got a lot to cover here. So, Todd, again, we're focusing on revocable trust planning. What information is typically needed about real property as part of that planning?
Richard, thank you for the invitation to be on the show, and thank you for the introduction. One of the key parts in our worksheet requesting information about property is real property. And specifically what we're looking for from the client is the address of the real property, where it's located, what the fair market value is, what the assessed value, and whether there is any debt on the property, whether it's financed.
Okay. Now, why is I think this is relevant, but why is the type of property important, as opposed to like rental property versus residence versus so on?
It's important as far as whether we can transfer it to the trust if it's financed. Residential property is typically immune. If it is financed, it can still be moved into the trust. But commercial or rental property, if it is financed, it is more difficult, and we need the lender's permission before we can retitle it.
So tell me, why is the state where the property is located important to know?
Each of us is subject to probate in the jurisdiction where we own real property. So if we have real property here in Fairfax and another piece in Florida, then that client, unfortunately, if it's not moved into a trust or other arrangements aren't made, will be subject, or rather their estate will be subject to probate in that jurisdiction. So it's helpful to know how many jurisdictions the client, or rather their estate, would be subject to probate in.
And of course, knowing that then helps you to plan on how you could then fund that piece of property into the revocable trust, if possible, to avoid that probate. Tell me a little bit, why is the legal owner of the property important to know as well?
There are many ways to hold real property. We can hold it individually in our own name. We might own it as tenants in common with another person, the way you might own property with a sibling or with a friend, where you each retain that interest even after death. And then, of course, you can own real property with rights of survivorship. We see that typically when we hold property in both names with our spouse through tenants by the entirety, where there is a right of survivorship, and after one owner's passing, the other owner is the sole owner of that property.
Yeah, I think you bring up a good point, though, and I think we always like to see a copy of the deed because people say they own a beach house. But when actual reality is that an LLC owns the beach house and they own part of the LLC. And so it becomes more of an issue about understanding what it is you have and how you own it in order to transfer properly. Dominique, I'm going to come to you now because Todd mentioned about the importance about, mortgages on a property can cause different types of issues. Why is it important to know if a property has a mortgage on it?
Absolutely. The reason it's important to know whether or not there's a mortgage is because the property could be treated in a different manner if there is a mortgage versus not having a mortgage. The terms of the mortgage document will then become very relevant. Whether or not the property needs to be paid off by the estate or the property needs to be financed by the new owner of the property, that's all going to be relevant as far as whether there's a mortgage or not.
So does the estate or the trust, as the case may be, have an obligation to pay off the mortgage on a piece of real estate when somebody dies?
No. At least in Virginia, there's a non-exoneration statute that says that normally if someone inherits a property, they inherit it with the liens that are on the property. So if someone wants their mortgage paid off by their estate, they have to be very specific about it and actually include that information in the documents to make sure that that particular debt is paid off.
I think it's important to know. I know a client recently was the recipient of a bunch of bequests of real estate from his family. And he said to me, well, doesn't the trust have to pay off the mortgage? I said, there's nothing in this document that says it has to do that. You take the mortgage with you. So hopefully they'll let you take it over, but sometimes you may be forced to pay it off or get refinanced. Before I finish with this line of discussion with you, Dominique, is there a probate tax in Virginia on real property?
There is if it goes through probate. And so what we mean by that is, as Todd mentioned, there are different ways to own the property. If you have, you're a joint tenant by the entirety, meaning that you have a spouse, your spouse would be the person to inherit that property, and then it would not go through probate and there would not be a probate tax on it. However, if it's someone else or it does have to go through probate because you own the property individually and you didn't have it in a trust, you didn't have any other sort of designation, then there would be probate taxes assessed against the real estate as it moves through the probate process.
So just from a financial perspective, if I have $1 million piece of real estate and that's gross value, not net of debt, then I have to pay $1,000 in probate tax, as I recall.
That's correct.
So that yes. begins to motivate people, I think, to kind of figure out a way to which to convey that property into their trust when they're doing trust planning. Now, in that regard, Todd, as I come to you, a lot of people say, well, I'll do the easy way out. I'm going to do what's called there's a thing called a transfer on death deed that some states have, including Virginia. Tell me a little bit about how that particular deed works, Todd.
Virginia instituted the transfer on death deed in approximately 2013, allows you to file a second deed on the property, and that deed is revocable. You can sell the property, you continue to control the property, but on your passing, the property automatically conveys to the beneficiary that is named in that transfer on death deed.
I think, and that can be sometimes a helpful tool, okay, if it turns out you're not able to do a transfer during lifetime. Are there any problems, Todd, though, in the use of a transfer on death deed? Any problems that you've seen in your practice?
I haven't personally run into any issues, but there always is the issue that when that transfer occurs, that other contracts related to that property don't automatically transfer as well. So if we're thinking about property casualty insurance, that will not transfer automatically to the beneficiary.
That's a very good point, and that's something that is very difficult situation to be that you need to be concerned about, and connecting with that particular thought. If you do decide in your planning to transfer real estate into your revocable trust, one of the things, of course, I know you talk about is you want to make sure you notify the fire insurance company to make sure that the trust is named as an additional insured. So, very important thing. I think it's a good point that you brought up. Dominique, let's talk a little bit about all the stuff that's in the house, the furniture and personal effects. What type of assets are we focusing on here?
These are what we call the tangible personal property. And so these are the items that we own: our clothing, furnishings, tools, artwork, that sort of thing, photo albums, things that are in the house, around the house.
So do these things typically have some sort of formal title?
No, I like to call these things things that are not easily retitled. You know, so when we were just talking about real estate, we were talking about deeds and recording deeds. There's not an easy way to retitle your clothing.
Right, and there are many people, and when they do revocable trust, the lawyers will draft a document to convey all of that tangible personal property as kind of a way to say all the knives and forks are now in the trust, okay? So we don't need to worry about those.
Yes.
But why is this information important? You know, why is all this, why do we even talk about this tangible personal property? Why is it important?
Well, again, when you mention having the trust and actually assigning all of this to the trust, it makes it really easy because those assets don't need to go through probate. But if you have a will-based plan, so there's not a trust, then you have to consider what's the size or what's the value of all of these assets. One of the things that we talk about in probate is yard sale values. And we're not trying to be offensive. We're just saying, even if you spent $1,500 on that sofa, if you can only sell it for $200, that's the value. And that determines whether you have a small estate that you're working with or a large estate. And then you might want to make sure that certain assets like jewelry go to certain children. Sometimes people say, I want to make sure that my ring goes to my son so that he can give it to his spouse. Those are the sort of considerations that we're making.
Now, Todd, I'm going to come back to you to talk because I think Dominique mentioned an important thing. With this type of property, is it typically given away by some sort of general bequest in the trust, or do you have to itemize in the trust all the details about where stuff to go? Tell me a little bit about how this is handled by most attorneys these days.
Most attorneys in states that allow it use what's referred to as a personal property memorandum, where the will or the trust can make reference to the personal property memorandum, and the client can then use that memorandum or that document to specifically list a type of asset. It has to be tangible personal property, and who the beneficiary is. All they need to do is sign and date that document, and it's automatically incorporated by reference into your will or trust. That allows it to be very easily amendable. So the client doesn't necessarily need to revisit their attorney and do an amendment to their trust simply because they changed who they want their watch to go to. So we generally will incorporate language into our documents that allow them to use a personal property memorandum to distribute their tangible items.
Now, that personal property memorandum has to be signed and dated, I guess, as I recall. Doesn't need to be notarized necessarily.
Doesn't need to be witnessed, does not need to be notarized.
Okay.
Not all states allow for that.
That's
but Virginia thankfully does.
That's a good point. Not every state's a little bit different on that. Well, Dominique, let's come back and talk about the next things. There's things that are sitting in your driveway or maybe down at the dock. That's with the automobiles, boats, and RVs. Okay, so
Yes.
What information is typically needed to know about these types of assets?
Again, you want to know the description, how it's titled, the market value, and whether or not there are any liens against this asset as well.
And do these assets have a formal legal ownership title issued by a state?
Yes, there are. So with automobiles, it's the Division of Motor Vehicles, DMV, for cars and RVs, and the Division of Wildlife Services for boats.
Okay, that's good to know. Now, if there's a lender lien on these properties, does that have any impact as far as how we handle those things, as far as in a trust-based plan?
It does. One of the most important things is that you might not actually have a title that's available to find. A lot of times family members are looking through important papers and they might not realize that if there's a lien against the automobile, the title won't be there with the rest of the papers. You also might need to pay off the lien on the asset in order to transfer it to a beneficiary.
Okay. So Todd, let's talk a little bit about title, because I think Dominique brings up a good point. How are these assets, cars, boats, RVs, how are these assets typically titled with the DMV?
They're typically titled in the client's name or jointly with a spouse or child. If it is joint, typically there's rights of survivorship there, so that the other owner will in fact own the property on the client's passing. If it's held in the individual's name, it would be classified as a probate asset. It would be includable in their estate, and there is generally a very streamlined process at the DMV by which the executor of the estate can transfer title with the DMV or Wildlife Resources.
Okay. Now, in some states, and I'm not sure all states, but certainly I think in Virginia, there is the ability to name a beneficiary for an asset like that if it's not held jointly. Have you seen that done from time to time?
Yes, I believe that can be completed on the back of the title, naming, just like you might in a life insurance policy or a retirement account, a designated beneficiary of that particular vehicle.
So if you're trying to avoid probate, people should keep in mind that you cannot name a trust as the beneficiary of a car on that title. You can name an individual, but not a trust. Todd, why is the value of this asset important to know?
It's important, just like all assets, collectively to look at what the value of the decedent's estate is. For number one, for probate tax purposes, but also for estate tax purposes.
And how do most attorneys recommend that these assets be titled, in your experience?
Typically jointly with a spouse or jointly with the beneficiary that you intend to receive that asset.
Okay. I mean, I think most people don't resist the idea of actually transferring the title of the car or the RV into their trust, unless it really is necessary, given the value. Dominique, let's talk about the next big bucket of assets that I think we want to finish up on, which is bank and brokerage accounts. So what information do you collect about these types of assets in the course of your estate planning work for revocable trust projects?
Well, we collect the account, the title of the account numbers, what type of account it is, whether it's checking, savings, securities. We want the account balance, and then who's actually, like I said, titled on the account.
Okay. And why is the name of the bank and the account balance and the account number important to know?
Well, it's helpful if probate is necessary, and it's helpful for your heirs or beneficiaries to be able to know where to look for various accounts.
So certainly the trustee it'd be helpful to your trustee. Todd, let me come to you, because I think I don't want to run out of time here. We have more to cover. Is it a good idea, in your experience, Todd, to add a child or a third party as a co-owner of a bank account or brokerage account just to avoid probate?
I generally recommend against that. If you named a child, for instance, as a co-owner on account, on your death, that child is the sole owner. You might give them instruction that it should be divided between the other children or be used to pay debts and expenses, but that is not their obligation. So when using a trust-based plan, I would recommend either directing that account to the trust so it can be included with the rest of the assets when they're divided, or leaving a POD, a payable on death, or a transfer on death to the beneficiaries that you intend to receive that after your death. In addition to that, there's some gift tax implications if you retitle an account, adding a child or someone else as a co-owner.
Okay. We have one category here that I want you both to talk about, and this is the assets that are in this bucket of things you might inherit, or gifts you're expecting to receive, or maybe judgments you have in a lawsuit that you filed. How are those things typically handled? And Todd, I'm going to stay with you to start with.
Those are typically part of your probate estate unless they've been directed to your trust. So if I'm a claimant in a lawsuit and on my death that lawsuit's still going on, there has been no settlement, then my estate would be entitled to receive any proceeds from a settlement or from a judgment.
Okay. Dominique, how about your thoughts? Anything in particular that jumps out to you there about inherited assets or gifts that need to be addressed in a revocable trust project?
One of the other things that I would mention, and Todd had mentioned this with like litigation that is ongoing. If you are no longer here, your estate would need to step in, and your personal representative or executor would need to be authorized to have your estate step in to continue the litigation if that's what you want. Also, you want to make sure if you're dealing with people who are under the age of 18, it's always good to have their interest within a trust. So their distributions are made out of a trust. If you do not, if you have their distributions passing through your will so that it goes through probate, the unintended consequence is that the courts are involved until they turn 18. So even though they might have living parents, there will need to be a guardian appointed to watch over those particular assets until they turn 18, and then they receive those assets.
Okay. Well, Dominique, I'm going to stay with you as we get to closing comments. Get a couple of things you might want to mention as we work through the first part of this particular program on revocable trust planning. Things you want to advise people about, suggestions, pitfalls to avoid that you can pass on to our viewers.
One of the things that I want to advise people to do is make decisions while you can make the decision. I've also spent a lot of years working with interventions, so guardianships and conservatorships, for someone who either didn't have an estate plan or it wasn't robust enough when they became incapacitated. So very important, make these decisions while you can make it and communicate it so that your decisions are honored.
Todd, how about yourself? Some final thoughts, recommendations, or pitfalls you would suggest people be aware of?
I would encourage people to be as transparent as possible with their attorney. If they have not made their attorney aware about the assets they own or the value of those assets, then we are not in a position to provide the best advice possible and to guide them appropriately.
Those are all very good suggestions. And I, on behalf of the Probate Nation and the television audience in Virginia and around the country, I really want to express my appreciation to Todd Spignato and from the law firm of Rees Broome and Dominique Braggs from the Braggs Law Offices for sharing all this really great information and their personal experiences. Thank you for this awesome and valuable public service, guys. You know, if you have plans to meet with an attorney to discuss creating a revocable trust, this show is an excellent preview of some of the asset information you will need to disclose. And next week, we're going to complete the review of that asset information. Hopefully, you will be motivated by these shows to carefully collect and disclose all the information needed about the assets in your estate. And if you do so, your revocable trust plan will accurately implement your wishes. Your family will thank you, and you will save some attorney fees along the way. This brings us to the conclusion of our show. I hope you found it helpful. Replays can be viewed on the Probate Nation YouTube channel, and if you want to receive monthly estate planning and probate tips, please sign up for the free Probate Nation newsletter at probatenationnews.com. Many thanks for tuning in. Until next time, I am Richard Ruddy, and this is the Probate Nation.